Welcome once again to 26 North Halsted. I am your host, George Blaise, and I know you guys are still enjoying these last waning days of summer, but March of next year, March 17th to be exact, there's going to be our primary elections here in Illinois, and not the least of which on there is going to be selecting Supreme Court justices for Illinois. Do you even know what the Supreme Court of Illinois does? Have you ever even heard any of the cases they've adjudicated? Are you even interested? This is things you need to know about. Who's running, who's coming, what seats are up, at least in this district. We're going to learn that today with Daniel Epstein, candidate for Illinois Supreme Court. Daniel, finally got you on. I've heard a lot of good things.
Good, I'm glad.
You run amongst some good people.
Absolutely.
You're Maya Pawar's brother-in-law.
Yeah, that's right.
He's good people.
He is good people.
Illinois Supreme Court. Why the Illinois Supreme Court?
Yeah, so the Illinois Supreme Court decides the biggest cases in the state. That's what it does do. But what it can do is much, much bigger because it writes all the rules of procedure, all the rules of evidence, all the rules of ethics. It determines things like design and architectural standards of courthouses, which turns out to be really important for access to justice for undocumented people, people with disabilities, trans people. It has a role to play in the data infrastructure of the court, in who gets to be a lawyer and how, and attorney discipline, on and on and on. They're like the chief executives of the justice system. And in all those ways, all those non-adjudicative ways, there's a lot of work that we can be doing to make sure that our courts are free of bias, of bad incentives, of judicial corruption. There are things that we can be doing on those fronts that we're not doing right now.
And that's kind of what separates you from, the other candidates that we see out here, in the fact that you're really focused on these non-adjudicative issues and things that the procedures and the way our courts work are almost as important as the decisions that are being made at the bench.
Yeah, absolutely right. It's like it sets kind of the structure on which everything else is decided. So what I like to say is even the most fair person can't achieve justice in an unfair system. We have to make sure the system itself is fair so that fair people can achieve that justice.
Now, of course, you've been an attorney, you've been all over the country, you've done this for a while. Something happened in 2016, a case came to your mind that really changed your thoughts about what you could do best to contribute to justice.
Yeah, that's right. So I was serving clients in the highest court in our nation, the Supreme Court of the United States, and in courts all across the country, and then came back to Cook County and was defending an individual accused of attempt murder. And DNA was at issue in that case, and my job was to learn everything I could about DNA and to mount his defense. So I read everything I could get my hands on, and we hired a forensic scientist, and I interviewed the state's DNA analyst, and what we found was something that was frankly scary, which is that the state was using a faulty DNA machine.
Faulty in what way? Can we? We're not getting too technical.
Yeah. So I mean, look, if you watch Law and Order, they're like, scrape that blood up off the carpet, throw it in the machine, it's going to pop out the magic answer. But it doesn't quite work like that. It's a little bit more complicated, and you have to calibrate those machines. And if you don't, you can get false positives and false negatives. That's what was going on here. But I thought, I was optimistic. I thought, even though this scary thing is going on, we'll go to trial. I'll put the DNA analyst on the stand. We'll cross-examine him. And we'll expose that information. They'll have to retrain the analyst. They'll have to fix the machine. We'll make the world a better place one case at a time. That's why I became a lawyer. That's how it's supposed to work. And I did a little bit more research. And what I found out was that in Illinois, our forensic labs get extra funding when they produce an analysis that ends in conviction. And I did a little bit more research. And I found out that in Illinois, our courts get extra funding when they convict. And that offends me.
Now, are the labs aware of the what's going on in the case as they're analyzing the evidence? That seems like that should not be the case.
Hard to say. It does seem like it shouldn't be the case, but it's hard to say what they know. And the lab itself is a series of individuals. It's possible that some know and some don't. Right. But it's hard to get economists to agree on almost anything except for one thing, which is incentives matter.
Right.
And in this case, there are financial rewards, not for finding truth, but for finding guilt.
Interesting.
And that's troubling. But I was still optimistic. I thought, look, we're going to go to trial. We're going to put this out on the table. We're going to expose these issues. We're going to make the world a better place. That's how it's supposed to work. But that's not how it worked. Because what ended up happening was we went back into judges' chambers under something called Illinois Supreme Court Rule 402. And in a 402 hearing, the state says, Judge, this is what we're going to show at trial. And then the defense says, Judge, this is what we're going to show at trial. And then the judge contemplates and says, okay, well, based on what you're telling me, I think an appropriate sentence would be 70-something years were I to convict. And then you walk out into the hall, and the prosecutor pulls you to the side and says, all right, you heard the man, 70-something years. But if you plead guilty, I'll ask for 20-something, right? And so the defendant has a choice. Do I assert my constitutional right to a trial and risk dying in jail, or do I plead? And in our case, he pled. And that
seems
ends the
to be the case most of the time.
Well, very difficult decision, right? Because 50 years, I mean, that's a lifetime almost, right? And he pled, and what that means is that ends the case. And so I don't get to put the DNA analyst on the stand, and we don't get to expose the bad machine, and we don't get to expose the systemic funding issues. That information disappears, right? And I wondered at that point, how common is this? And in Illinois, 97.5% of felony convictions are guilty pleas. Right? That's a lot of disappearing information.
Certainly.
And it solved a puzzle for me. And the puzzle was this. How does John Burge do it for 20 years, right? John Burge, the Chicago police commander who electrocuted people and tortured people and helped falsely convict people. Functionally, how does it work? How does someone like that get away with it for 20 years? And this is how it happens. Because it's extremely difficult to expose patterns of misconduct when you don't get anything on the record, or very hard to get things on the record, right? And there are processes that we can be using to make sure that kind of information gets on the record. They're called trials, right? We don't really do them very much anymore. But even short of trials, we can do depositions. Depositions are like putting someone on the witness stand before the trial. You get information on the record. And in civil cases, when money's on the line, we do them. But in criminal cases, when liberty's on the line, we don't. Other states are different. Other states have depositions in criminal cases. We should too. And that's something that we can change through the Illinois Rules of Evidence. But only the Illinois Supreme Court can do it.
That's one area. I tell you what, let's take a short break. When we come back, I want to talk a little bit about your background and what qualifies you to be making these kind of decisions and qualifies you for the Supreme Court. Stay tuned. Back with more with Daniel Epstein in just a moment. Welcome back to 26 North Halsted, talking today with Daniel Epstein. He is a candidate for Illinois Supreme Court. Don't forget to get out to vote March 17th. I know it's way ahead of time. We'll be back with more of this later on. But Daniel, there's 7 people running for Justice Neville's position as seat on the bench. You're the only one who's not currently a judge or hasn't been a judge. A lot of people might look at that and be like, well, clearly you're not qualified, you're at a disadvantage. Is there anything that in the rules that precludes you from running? And what is it about who you are and what you do that actually makes you more qualified in your mind?
Yeah, not only is there not a rule that precludes me from running, but as a point of fact, more than a third of all justices of the Supreme Court, both U.S. and Illinois, were never judges before serving on the bench. So great liberal judges: Earl Warren, Louis Brandeis, Elena Kagan, who's on the bench right now, Thomas Kilbride, who's on the Illinois Supreme Court right now. They were never judges before. It's actually quite common. Okay. And actually, I'll be 35 when I take the seat. At 35, that would make me, if this were the first Illinois Supreme Court, it would make me the oldest justice on the bench. Okay. So things have changed a little bit.
Changed quite a bit, right?
But for many years, it was not that uncommon for more youthful individuals to serve on the bench. And that's changed over time. But look, in terms of what I've done,
I guess in people's mind, particularly since this is an elected position there, they're thinking, well, clearly the machines always said that, don't send us nobody nobody's heard of, or,
yeah,
what
right.
I mean? And it's kind of people think the same way about this. And it's like, it's time to kind of do away with that. We've seen that there's kind of been a wave in the last 10 or 15 years here in Cook County and Illinois in general, that people are doing away with that thought of how politics works.
Yeah, I mean, look, if you keep selecting judges the way we've always selected judges, we're going to keep getting the justice system that we've always gotten. I think that's an unacceptable system. The status quo is not good enough. We need to do better. And so I think we need to think about who we put on the bench in a more holistic way. And I'm really proud of my experience. Look, I've served clients in the highest court in our nation, in federal courts of appeals, federal district courts across the country, state courts across the country. I've built a court system, an online dispute resolution platform. And I drafted all the rules for that. And so the things that I am trying to do for our public system, I've done to the extent that I can in the private sphere. But we can't, writing those rules that the way I've done it, we need someone who makes that their focus. Makes that their focus also for our public system.
One of the other things that sets you apart that I've noticed is that you're really progressive in looking at the things we can bring into the system that aren't there before, that can improve, make more efficiency, and bring justice to places that aren't getting them equally. One of the things you think technology plays a great role today in the way that we use technology, and how that can also help bring efficiency to the bench. Tell me a little bit about that.
Yeah, so merely being able to set foot in a court is a privilege that some of us have that not all of us do. So let me give you a little story. So some years ago, I met with a group of individuals who had just been laid off from a factory here in Cook County. They were all undocumented. and I asked them, how many of you have experienced wage theft, right? Your employer not paying you what you're owed. Every single hand went up. And I asked them, how many of you have sued the people who stole your wages? And every single hand went down. And it's because those people won't set foot in our state civil courts because they're afraid that if they do, ICE will be there to arrest them, detain them, and deport them. So that's a subsidy to wage thieves and abusers, right? We are enabling them to do what they do. They know that the people that they are stealing, whose wages they're stealing, won't set foot in court to sue them. So we have to make that easier, and we can do that using technology.
And this is not, I mean, when you think about this, it makes me think of, on many levels, even if funding for college, getting money for college, filling out a FAFSA form for many undocumented people, they're afraid to fill out the forms for their kids because, well, now my name is out there.
That's right.
Now ICE is going to come get me.
Yeah, and that's something that resonates with me personally too. I mean, my grandparents were survivors of the Holocaust, and when they came to the United States, they wouldn't sign up for credit cards, they wouldn't do banking, they wouldn't do anything where they had to put their name down on anything because they had truly been hunted, right? There are people right now in our society who are being hunted, and they won't put their names on a FAFSA form. They won't set foot in our state civil courts. There's a huge price to pay as a society for that, and it's enabling those hunters, those abusers, those wage thieves. We can do better, and one of the ways we can do that is by using technology to make it easier for people to access our courts, right? We can use the webcams on the cameras on our phones and our computers to allow people to make appearances in court. And
individuals who are in jail, they do it all the time.
That's right.
They're standing there in handcuffs via telemonitor talking to the judge.
Absolutely. The technology's already there, right? Some jurisdictions are already doing
What do you think
this.
is the resistance to that?
I think some of it is just a lack of fresh eyes in the areas where
you know how
those
frustrating it is
made.
to have to go to traffic court out there by Arlington Racetrack when I live in the city and the cop doesn't show up.
Right.
I have to take a day off. I had to drive out there. I'm not going to the racetrack.
Right.
It's a whole thing. And if I could have just sat there on my phone on a secured app or something like that and done the court there, we could just get it done in a manner whenever it's convenient for everybody.
That's right. That's right. I mean, and people have childcare responsibilities. Not everyone can take a day off work. Judges don't even always call your case on time. You don't know how long you're going to be there. So it's kind of we can have our cake and eat it too kind of thing, right?
And we need to, in Cook County, we need to update that little video they play when you're sitting there for jury duty.
Yeah.
Like Lester Holt doesn't have that much hair anymore. We have to really.
We need George Blaise. We need a video with George Blaise.
That's right. If we can
start that after
Tim Evans can get his hair done, I can get my hair done.
Let's make it happen.
In all seriousness. Undocumented people in this issue this whole immigration issue is one of those big things. What would you say are the three key issues looking from being a future Supreme Court justice that will come across your docket that really impact your heart and that you're really going to bring the stuff to?
Yeah, first is the one that I already talked about, which is we need depositions in criminal cases. We need to have that system, that procedure in place that allows us to develop information so that we can reveal pattern misconduct. That's one. The second is we need to change what's called Illinois Rule of Evidence 702. It's the expert admission standard. As it stands right now, we have a standard called the Fry test, which says someone qualifies to be an expert witness so long as they use a technique that is, quote, generally accepted in their field. And what that means is pseudoscientists like forensic odontologists, which is a fancy way of saying dentist, can get on the stand and say, yep, I know that the suspect bit the victim because I've looked at their teeth and I've looked at the injury on the victim and I've correlated the two. They've been able to do that for decades, in part because they passed the Fry test. But now that research is being done on that topic and others, we know that in best case scenarios, they're accurate about 2% of the time.
Okay.
The FBI has abandoned this practice. Nevertheless, people linger in jail to this day because of that, right? We can change it to something called the Daubert test, which is the test used in federal court, which says you have to use a technique that's reliable. That's a better question, right? So that's the second thing. And then the third is we need to change our system of recusals. Right now, at the appellate and Supreme Court level, we allow judges and justices to make the decision for themselves as to whether they have a conflict of interest in a case, right? So let's say you're suing Sludge Corp, and I'm the judge, and my life savings are invested in Sludge Corp. You don't want me deciding that case because if I decide it for you, I lose money. If I decide it for them, I make money, right? And that's not a good way to achieve justice. You will then say, hey, I don't want you to decide my case. You have a conflict of interest. I'm the one who gets to decide whether I get to decide your case, right? in other areas, we do it better, and we have a disinterested individual making the determination as to whether I have a conflict that precludes me from deciding your case. Right. That's a better system. And that's one that we need to.
A lot of the stuff that you're saying right now sounds very common sense, but unless you've actually encountered the judicial system at this level, you wouldn't even know that we're still living in the 1800s in many ways.
Absolutely, absolutely. You know, this is what I've been saying. I think there's a place for fresh eyes on the court. These aren't necessarily all super complicated things. Right. They're just things that are long past due and need for changing.
I tell you what, let's take another short break. When we come back, we'll have more Daniel Epstein, candidate for Illinois Supreme Court, when we return. Welcome back to 26 North Halsted. Today, talking with Daniel Epstein, candidate for Illinois Supreme Court. Don't forget, the election is March 17th. It sounds so crazy for me to be saying that, and we're not even through August yet. But you know, that's the way it goes sometimes. Daniel, if you do a cursory overview of the website for the Illinois Supreme Court and look at the docket there's quite a number of cases on the docket dealing with Second Amendment rights and rules. And we have such a strange thing going on with guns here in Illinois, where large portions geographically of the state are, you know, very rural and have different thoughts about guns. And then you have Cook County and DuPage County, things which are a little bit different. This seems to be a big issue. And some of these cases, how they're going to pan out, are going to change things fundamentally about guns here in Illinois. I was wondering if you could comment a little bit about that.
I wish I could, but I can't, because judicial candidates are prohibited from making statements that would commit them or appear to commit them to how they decide cases. So I wish I could, but I truly can't. I really can't.
There's some exciting stuff going on all around there. Procedures, rules, ethics, and evidence is what you're running on there. Who are some of the other people, of the 7 people who are running? You respect these people as well. It's not like you're enemies of any of them.
Yeah. No, that's right. There's a great quote that I like to say. G.K. Chesterton, he's a British poet. He says, the terrible thing about all legal officials, all lawyers, all policemen, all judges, all detectives, is not that they're evil, many of them are good. It's not that they're stupid, many of them are quite intelligent. It's simply that they've gotten used to it. They no longer see the prisoner in the dock, they just see the usual man in the usual place. I think that's really what the issue is. It's not that these are bad people or unintelligent people, quite the opposite. I have great respect for them. I think that there just needs to be one person with fresh eyes on this court to bring these new issues, I shouldn't say new issues, these issues that have been ignored for too long to the forefront. That's really what I'm trying to do.
Is it challenging to, this position as a judge on the bench of the Supreme Court, to have to do politicking, to have to run for this office? I know that's the way it's done here, but in your mind, how do you put that together? It's like, I'm not a politician in that sense. I'm just trying to be a public servant, but I have to actually express to people why I might be a better choice than someone else.
Yeah, it's bizarre. I mean, I can't tell you how different running to be a judge is from the practice of law.
Right.
It's a totally different mode, and it takes some getting used to. It is very difficult. I'm enjoying it because it gives me an excuse to go out and meet folks and interact with neighborhoods and communities that I wouldn't necessarily otherwise go out and interact with. But it's very different. It's very different. And people look at it in multiple different ways. One is there's a positive aspect in folks getting to know the judges who are going to be overseeing their cases and their justice system. The other way is it's really important for judges to get to know the people whose cases they're going to be deciding. I think that's actually even more important, to kind of have a system that requires interaction and empathy, right? But there's a third aspect, which is politics can be a dirty game. Right? And you don't want your judges to sully themselves in the process.
Certainly.
And one of the ways we can protect against that is that system that I was talking about before, getting disinterested individuals to make determinations about conflicts of interest, right? So if someone writes a judicial candidate a huge check to fund their campaign, you might be worried that they are not going to allow truth to dictate their decision if that person ends up before them in court. It shouldn't be the case that the judge themselves gets to decide whether they decide their case.
Right.
A disinterested person should do that, and that's especially important in a system where we elect our judges. Right? It's called auto recusals.
Right.
The idea that a judge will recuse themselves And it's a very common system. We even do it in the federal system, auto recusals. But the difference is, in the federal system, our judges aren't elected. They don't have to go around politicking and fundraising and doing all these things, right? Here we do. And so there's an extra reason that we have to make sure that judicial integrity is assured structurally and not just anecdotally. It's not enough for candidates to say, I'm super fair. Don't worry, I'm going to be really fair.
Right.
We have to create rules that require them to be fair.
And of course, things have changed in the most recent history. I mean, for the first time in decades, we have a sitting judge that was not reappointed to the bench based on the work of, Judicial Accountability PAC and other organizations to really educate the public on the records and what this judge has done sitting on the bench that you might not have noticed if you never came before him. But when you start to see a pattern of behavior towards certain segments of the population, clearly that's something people should really know about when they're going in and just looking at a bunch of names and saying, well, whoever the Irish guy is, I guess that's the one who's going to stay in there.
Yeah, I couldn't agree more. I mean, it's too late for me to change my name to Osteen, so I got to run with Epstein. But but no, I think that's exactly right. It's critical to understand who our judges are, and to have judicial accountability. We require accountability throughout our political system, and it seems like our courts are one of the few areas where we just don't have as high a standard or an expectation for that. And part of it is it's just difficult to understand what a judge actually does. We have to change that. That's part of what I'm trying to do, is say, look, here's what we actually do. Here's what we actually can do. And hold us accountable. Because if we just point the finger at police, or if we just point the finger at politicians, we're not going to be able to solve these really big issues.
And then that's one of the scary things, is a lot of this stuff goes on anonymously and no one pays attention to it, knows it, until you see a headline saying, oh, this judge convicted a bunch of young black kids because he's tied into the prison system in that particular district and is getting a kickback for convictions. I mean, that kind of stuff comes out every, 2 or 3 times in the last couple of years. This has gone on with no one noticing.
Right, yeah, there's that famous case from Pennsylvania where there was a judge who was sending juveniles to juvenile detention facilities and found out that later that he was getting kickbacks. I mean, this is really disturbing stuff.
Right.
We have to have processes in place that allow us to know when that's happening, and so we can prevent it before it's too late, because that guy was able to ruin lives for years.
All right, tell you what, let's take another short break. When we come back, we'll have some closing thoughts with Daniel Epstein. Stay tuned. Welcome back to 26 North Halsted, a very insightful and educational conversation we've had today with Daniel Epstein, candidate for Illinois Supreme Court. Daniel, people are still, they still, the grill's out. I haven't put the cover on the grill yet. It's still summer. The election is in March. Did you know that Major League Baseball starts on March 26th next year?
How about it?
What if there's snow on the ground? I don't know how that's going to work. But beyond that, so what's the rest of your summer look like? Like, where do you go from here? You got a long road ahead.
Yeah, look, it's just meeting people over and over and over again, shaking a lot of hands, going to a lot of events, getting in front of folks like you and trying to kind of amplify our message so that more people can hear what we have to say. That's huge. That's everything. That's the whole deal, right? It's us just trying to persuade. It's kind of actually, it's not that different from what I would do in a courtroom, right? I'm trying to persuade 1 or 12 people in a courtroom. Now I just need to persuade, 6 or 7 million people.
I think your biggest obstacle, your biggest enemy is people's apathy towards the judiciary system, because they're like, well, I'm never really going to encounter it unless I get sued or sue somebody or commit a crime, which most people, maybe once or twice in your life you'll ever encounter it. So why even be educated or bother with it?
Yeah, I mean, my experience is people are apathetic because they haven't necessarily heard a message that's responsive to their interests, right? And when we go and talk to people, they are not apathetic. I can tell you, I mean, that is not my experience. I talk to them about the things that we've been talking about today, and they're shocked by the details, but they're not persuaded in some ways because they already believe that our justice system is broken. Okay. They're already there. They just don't know exactly how. But the interesting thing is they really get on board. They become really supportive when I tell them, we can fix it. They've never heard that before.
Right.
And they are not apathetic when I tell them that. People care about our justice system. It does not take a big imagination to see why it's important. It's just that they've never heard someone who has told them that we can actually fix it. And how? And
that's by doing things differently than have been done before. And without being disparaging to Justice Neville or what have you, he was handed the seat and kind of believes that it's his to keep until he decides to give it up, which a lot of judges feel that way. They feel entitled to it. Since the Judge Coughlin thing happened last year, I've seen videos out here where there are people in the appellate and the circuit court judges. Now there's like a counter to the judicial accountability where it's saying, we're in danger from these left-wing crazies. And it's like, it's blowing my mind. It's like, you're supposed to be a judge. What are you talking about?
Yeah, I mean, look, people, it doesn't take much to get people to feel attacked and go on the defensive, and I think that's...
It's not attacking you to pull out your docket for the last 10 years and see that you spent 30 seconds per person in bond court throwing, bond court, I guess you can't talk about it.
I can talk about bond court.
You can talk about bond court?
We
got a minute or two here. I just want to make sure.
Yeah, one of our big issues is ending cash bail. That's something that we can do through rules reform, right? John Cass in the Chicago Tribune just had 2 columns that was right on this issue. And I think it's really important to clear one thing up, which is I share his and others' concerns about releasing people on bond who are high-risk individuals. Cash bail doesn't make us safer.
Right.
It just makes it so that people with the money can get out, including dangerous people sometimes, right? It conflates 2 issues. Are they safe to return to the community, and can they afford it?
And we have like 30 seconds here. What about a civil asset forfeiture? That's one of the things I really have a problem with as well.
Yeah, so I mean, this is a big issue regarding, we have to pay very close attention to incentives. Incentives are critical, and where the incentives are to achieve something other than truth, we have to take, we have to acknowledge that, and we can do that through judicial notice in a court.
Well, Daniel, I love what I've heard today. I'm glad you're the first one of the candidates that's come on the show today, and then now it's got me interested. I got to hear what some of these other people have to say.
Absolutely.
But I hope as we move further down the line, we can have you back and get more in depth on stuff.
Great. Make sure you ask them what they're going to do.
What are you going to do?
Thing.
Ask them, what are they going to do? I get asked that every time I get home. Like, hey, what's for dinner? Well, what are you going to do? If I have to deal with that, judges should deal with it as well. We'll see you next week right here on 26 North Halsted.